So good morning, everyone, and thank you for joining us this morning on this particular webinar. We really appreciate you for joining us. So my name is Onesmus Masui. I'm the head of Premier and Wealth at Absa Bank Kenya. A couple of weeks ago, 12th November to be precise, we hosted our first webinar on succession planning, where we majorly focus on wills and trust. And from that particular session, we received very good feedback. It was overwhelming. We were able to receive so many questions, so many queries, and hence the reason why we set up this session today, so that we can be able to address some of those questions that came out of that particular webinar. If you missed it out, not to worry. We have already uploaded the video on our YouTube channel, Absa Bank Kenya YouTube channel. And so if you have time, kindly just go and look at it. We've also received some queries about whether this session is applicable to business owners, and I can confirm, yes, it does. If you want your business or your enterprise to outlive you, then this session is also for you. So we do have our team of experts, our partners, Mboya Wangongu and Wayaki Advocates. They're here with me. I'd like maybe to introduce them. So the lady at the far right there, Ivan McKenna. Ivan is a senior associate with over 6 years experience in estate planning, a certified arbitrator with a solid foundation in dispute resolution, a company secretary with a background in corporate commercial law. The lady in the middle, Patience, Lucky. So Patience is a principal associate specializing in estate planning and corporate commercial law. She's an advocate of the High Court of Kenya, a member of the Law Society of Kenya, and the Institute of Certified Public Secretaries of Kenya. As a corporate commercial lawyer and a registered company secretary, Patience provides integrated succession advisory covering both personal estate planning and business continuity. The lady next to me, Sheila Motiga Molinge. Sheila is a principal associate at Mboya Wangongu and Wayaki Advocates. At the firm, she practices real estate law and estate planning. Through her background in transactional real estate, Sheila understands the legal mechanics of property transfer and integrates thoughtful estate planning to her will drafting to ensure legal enforceability. So one thing I can confirm to you is that our panelists are very passionate about guiding clients through complexities of family dynamics with clarity and care, while helping them develop practical, legally sound wills, trust, and succession plans that safeguard their legacy and future stability. So we would like you to post your questions on the chat, as well as the Q&A tab at the bottom of the screen, and we shall be able to address some of them as we move along. Before I hand it over to Ivan, I'd just like all of us to just sit back, let's engage and learn together. Thank you, and over to you, Ivan.
Thank you, Onesmus, and thank you for having us again. We are happy to be here. As Onesmus said, there were a lot of questions that came from our previous webinar, which we were not able to handle then because of time constraints, and we thought it was necessary to speak to you, our audience, and just to address every question that you had raised and any other questions that you may have today. So this is why we are here today, and we're happy to be here, and we hope that you will engage with us and feel free to ask any more questions that you may have. As Onesmus stated, there's a chat box below you on your screen, and there's a Q&A box also. We have a team on the background from Mboya Wangongu and Wayaki Advocates who are ready to answer any questions that we have. The goal today is to ensure that all your questions are addressed. And in case the panelists here are not able to get to your question, please post it, and the team behind will ensure that they have answered your question. So thank you for joining us. And maybe just to touch base with you guys, because you were here about a month ago, after our webinar, what do you remember from what we trained on? We discussed the basics of wills. We discussed the basics of trust. So maybe you can tell me in the chat, what is one thing that you remember from that, or one question that you feel like you want addressed, or one thing that became clear after the presentation last time? So I am looking at the chat box and waiting just to hear from you and to hear what you've had, or even what you know generally about estate planning. So feel free to share your thoughts on the chat. And I will ensure that we look at some of them. And as you do that, we also want to hear from you. Because of the webinar last time, I think there's a lot of call to action for you to plan your estate. And in different ways, we taught you about different tools that are available, including wills and trust, which we went in depth on, but there were other tools that we discussed. So I can see someone saying, I missed the wills webinar, or rather, they did not, you missed it, the other people missed it. Okay, I think maybe just to answer this, Onesmus has already confirmed that Absa Bank has uploaded that webinar on their YouTube channel. So please feel free to go and listen in, and you will hear everything that was discussed on that day. So maybe we can just move on and we can discuss what you know and discuss the questions that came from that webinar, even if you're not present. Someone has said estate planning isn't just for after you have passed, you can do it before. That's true. You don't plan your estate just to cater for what will happen when you're no longer here. It is possible to plan your estate to begin working for you now, even while you're still alive. Yeah, so that is one of the attendees who's stating that. And we will discuss these other questions on cost today, because they did come up during our last webinar. So that will be addressed, so worry not. Okay, so I'm going to ask that for a poll to be put up, just so that I can hear from you guys, the audience, before we move on to our panelists and ask them a few questions. The poll should be showing on your screen in a few minutes. And the first question is, we want to know, do you have a will? Just let us know. We would like to just hear from you and see whether you have a will or not, however it is drafted, whether you did it alone, whether you wrote it alone, or whether you went to a lawyer. Do you have one? And if you do have a will, how many times have you updated it? Yeah? Did you know that you needed to update it? So let us know. If you don't have one, why? Is it because you feel like, oh, you're still growing your wealth? Yeah, and you still need a little more things before you can draft your will? Or do you feel like you're a bit young, you have time? I mean, these are not things to think about now. Or you have already declared your wishes to your beneficiaries, so you feel like that is sufficient. What do you think? Or you're worried that doing your will means that you're inviting death? Do you think that? So please answer the poll. Please engage with us. I'll give you some time to do that. And in case you feel like the answers provided are not sufficient, feel free to post in the chat what your answer is. I would also like to hear, if you want to give more explanation, feel free to post on the chat. So I think we can now show the results of the poll. They should be coming up on your screen for a bit. So on the first question, do you have a will? 10% of you said that you do. 10%. That's a bit concerning. Yeah? And 90% have said that you do not. So maybe let's move on to the ones who have a will. Have you updated your will? 46% of you said never, you didn't think you needed to. And it's not always necessary, but we will also explain why you may want to think about updating your will regularly. 4% of you have said you've updated at least one time, which is great because you're thinking about your circumstances, maybe things have changed, maybe you've bought more assets, maybe your dependents have increased and you needed to cater for them. And another one, some of you, 50% have said it's your 2026 resolution to do so. And we're happy to hear that. That's a good resolution to have. Just don't let it go beyond February. You have to start it, gear gears starting from January for you to update your will. But congratulations on having a will. It is a big step that you have done, so we have to congratulate you on that. Now, for those of you who do not have a will, you've said you have not prepared one because majority of you, 52%, have said you do not have enough assets. I think one of the things that we really want to debunk today is that having a will doesn't mean that you have to have amassed a certain amount of wealth. It doesn't mean that you need a certain amount of money or assets for you to prepare a will. It is possible to start your will now with whatever you have. And you have something. We promise you do. That car you drive to the office, that's an asset. Yeah? Those things you have in your home, even if it's a rented home, those are your assets. That small investment you have made in an MMF, that is an asset that you need to state and include in your will, because anything can happen at any time, and it is important that you express your wishes clearly. And again, if you do continue amassing wealth, you can always update your will, and it is easier to update than it is to start from scratch. So updating as you go along is much easier, and it also forces you to think about your estate, even as you acquire assets. So I hope that is clear. Then 14% have said you're young, you have time. True. Maybe you have 50 more years or 20 more years or 30 more years. But I want to think that a lot of you probably have pension, yeah? And pension is going to come when? When you're 60? And if you feel like you're young, maybe 30 years later, but you still have pension. Why do you have pension? Because you have to plan for the future. So it is important even if you're young, to still plan your estate at whatever age that you're at. 14% of you have said, I have told everyone my wishes. We're going to discuss that a bit today, because a lot of people state wishes, believing that they've stated their will, but then their wishes are not respected, or it is not considered a valid will. And we will emphasize and show you why it is important to consider writing down your will. Yeah? And then the last percent, 20%, again, a bit concerning, saying that not trying to invite death over here. I mean, true. I know that a lot of you, there's a lot of cultural backgrounds that we have, where we come from, where you believe that doing a will means you're definitely inviting your death. I think maybe what we want to emphasize is that when it's your time, and it will not come any sooner or any later. And it is very important that you plan your estate. It's a myth. It truly is a myth. There is no study that has shown that once you do a will, that your death will come sooner. And we can also talk about clients that we have seen who have done wills and who come and update regularly, who are still alive and very healthy. Thank you for answering, and thank you for engaging with us. I think now it's time that we move on to, I don't know if there was anything in the chat. Let me quickly see that. I have already learned something. Pension is a form of a will. It's a form of an estate plan. Yes, good. I'm glad that you've already got that. Someone has said, I suppose you're saying you haven't done a will because it may create conflict among family members. I think what I want to hear from this particular person, explain to me, why would it create, why do you think it will create conflict? I would like to hear that, because usually we see the opposite. We see when there's no will is where conflicts usually arise later on. So maybe you can give us more understanding on that. Someone else has stated no will due to lack of knowledge about how to go about it. This is why we are having this session today, and we hope that once you listen to this session and look at the YouTube that we had, the session that we had that on YouTube, you will have a guidance on where to at least start, which I can actually state here is just start by speaking to a lawyer. And preferably us. And then we will guide you on the next steps, and we will help you do that. Then someone else, so the rest are questions which we will take as we go along. But now I'd like to move on to my wonderful panel today, who are ready to answer a lot of your questions that you raised during the other webinar. and we will show you the questions that were raised, and they will address all of them. But as we stated, please feel free to post any other questions that you may have, and our team behind the scenes will ensure that they answer them. Okay, so moving on to you, Sheila. Thank you for coming. I think one of the things that came up from the other webinar is a lot of people trying to understand, why is an oral will not enough? What does it mean? Why can't I just state my wishes? Must I write down my will? Could you please help the audience understand what is the importance of writing down your will, or when is it considered valid? Is an oral will not valid at all? Yeah, please help us demystify that.
Yeah. Thanks, Ivan. That's a really good question. And this is a good opportunity to clarify and to just address whatever question, whatever fears people have when they raise this question. So the law provides for two types of wills, and it provides for both a written will and an oral will. So a person who wants to make a will, first of all, has to have the capacity to make the will. And that means they need to be an adult, and they need to have sound mind, and they need to want to make the will. Not because anyone has forced them, it's because of, out of their own free will. So once that is established, then someone chooses between the two types of wills, which one they want to prepare. So a written will is in written form, meaning that there is something to refer to, for years to come. And the oral will is it's verbal. So the main distinction between the two is that there's one that you can refer to for time to come, and there's another one that you cannot really rely on for very long because it is verbally created. So the complexity with oral wills comes in because the law provides that it's only valid for a very short time. And the time limit is 3 months from when it has been made. So now if someone makes the will orally in the presence of their family members or in the presence of whoever it is they want to make the will before, if they pass away after 3 months, then that will is not valid legally. So it means that the law will take it that they've died without a will, and the rules of intestacy, which is really the rules surrounding someone who's died without a will apply. So we usually encourage people to do a written will to avoid the application of the rules of intestacy and to ensure that there is something that can be referred to when time comes to distribute their estate according to their wishes. So yes, an oral will can be made, but it has that catch of being valid for only 3 months. And so that is why we advise that a written will is better. Yeah.
So that's interesting to know, but I think now with technology, the way things have moved, a lot of people are asking, the issue with the oral will maybe is memory, but now that I can record it and the record can be seen later, is that sufficient? If I record myself stating my wishes, is that sufficient? Is that considered a valid will?
I understand where that question comes from because, times have changed. Things are moving. We now have technology that makes life easier. Unfortunately, our laws on succession are still stuck in the past. And so they are very rigid when it comes to what an oral will is and what a written will is. So courts have held that electronically recorded wills still fall under the scope of oral wills, meaning that they're only valid for 3 months. Even if you can still refer to them later, the law still considers them as oral wills. So if someone wants to record their wishes electronically, that's fine, but they need to know it's only valid for 3 months. And so they need to go a step further and prepare a written will to ensure that their wishes are upheld at the time when they pass away.
That's interesting. So even if it's recorded, it's still considered an oral will, only for 3 months?
Yes.
Okay. That's interesting to know. And maybe we've seen a lot of families, I personally have seen a lot of families where people have written down, someone has written down their wishes just on a piece of paper. It has not been signed. They've just stated, I want this land to go to this person. There's even a sketch of how the land looks like, who's getting part A, part B, part all that. And maybe you can help us understand patience. Will that be valid? And can that be produced as a valid will in court?
Well, that's a very interesting question. And yes, we have had those questions from our clients. If you are making a written will, there are requirements that have been stipulated in law that you must meet. One, a written will must be in writing definitely. Two, it must be signed by the person making it. In this case, we call them a testator. The third one is that that person who is signing must sign in the presence of witnesses who must be competent and independent. Four, you must provide for all your dependents. You should not leave out any of the dependents that are listed in the law. So this, and you must also have capacity. You must be of age and you must have sound mind. You should be able to understand what you're doing while preparing that will. So these are some of the requirements that are stipulated in law that you must meet for that will to be valid. So if you write your will in a piece of paper without signing it, without meeting any of these conditions stipulated in law, then that will not be upheld in court.
Thank you for that. I think that's usually one of the gray areas. A lot of families just write down and they agree on what will happen. I have even seen minutes of a family meeting written down agreeing on how things are distributed. But I think I hope we now understand that those are not sufficient to qualify to be a will. That there are certain requirements that the law has provided about what constitutes a will, and that it has to be signed and witnessed by 2 witnesses. Now, Patience, you have mentioned independent and competent witnesses. So maybe to demystify that and just to help the audience understand who is an independent witness and who is a competent witness?
Yes, thank you so much for that question. A competent witness is someone who has the capacity to witness you signing your will, or if in the case of an oral will, to witness you making that oral will. So this is someone who is of age, must be above 18 years, and must have sound mind. So that is a competent witness. Now, when it comes to independent witnesses, these are people who are not beneficiaries in the will. They are not getting any of the assets in your will. So they are independent. They do not have any conflict. That is who an independent witness is.
Okay, and maybe just to help also the audience understand. So if my child witnessed my will, what happens? Does that mean my will is invalid?
Well, if there is another, one, it is not invalid. It just might not be having an executor if it's a written will. So if your child, I'm assuming this is a minor, is below 18, they don't have capacity. So the will still be valid, but the court will have to appoint an administrator, someone who's going to execute the wishes of your will. However, if you had appointed someone else, that other person may be the executor. And if the child is not a minor, but they are beneficiaries, then we advise that ensure that their signature is also attested by an independent witness. That way you cure the problem of not having an independent witness. Remember, we have mentioned, and Sheila has rightly mentioned, that a will must be attested by competent and independent witnesses. So if your child executes or other witnesses your will, then it's advisable that you have other independent witnesses see or other witness their signature. However, in the best case, just have independent witnesses, people who are not beneficiaries and people who have capacity, who are not minors, witnessing your will.
Okay, so this means that, one, I think what I'm getting from you is you have to have independent witnesses. So avoid your beneficiary signing your will, yeah? And they have to be above 18, and they have to have capacity. Now, how many witnesses must I have? And just so that I can understand, because one of the concerns that clients usually have and people usually have is, must they know what is in my will? And you know, I don't want my lawyer, or your lawyer may know, but I don't want my pastor or my neighbor to see how many properties I have and where they are, what I have written in my will, and who I have given. So must my witnesses know what is inside my will?
One, I think you've asked two questions. One, whether the beneficiaries or the person signing, rather, the witnesses, whether they need to know what's inside the will. They need not. What witnesses are doing, they're witnessing you sign. So they don't need to see what's inside the contents of the will. They just need to see you sign in and confirm that they have seen you sign in and sign against your signature. As to the number of witnesses, the law prescribes 2 or more. So a minimum of 2. Yes.
Okay, thank you so much for that, Patience. I hope we have all heard that, and I hope that you've understood that concept. And if you have any more questions in that line, feel free to post it in the chat. But now we are going to move on to something a bit different. You have mentioned, it has been mentioned here by Patience, executors, yeah? And you've talked about having an executor in a will. So maybe, Sheila, you can help us understand who is an executor? And what role do they play in their will?
Thanks, Ivan. So an executor sounds like a really big word. But basically, it's someone who you appoint as the maker of your will. You appoint someone who you are giving the responsibility of ensuring that your wishes under that will are implemented. So they have, first and foremost, the responsibility to ensure that whatever it is you've written in your will comes to pass the way you want it. So now you've prepared your will, you've appointed your executor. How do you, how do they start out on the roles that you've given them? So an executor, first of all, needs to be informed by the testator, the person making the will, that they've made a will, that they have appointed them as an executor. And we also advise that they let them know where that will is, because their responsibilities start at the point when the maker of the will has passed away. They would ideally inform, if it's a lawyer who is storing the will, that the person who's made the will has passed away, so that now the family is gathered and the will is read. Then from that point, an executor would have the responsibility to start the court process. It's important to know at this point that when someone passes away, an executor cannot deal with their property until they've gotten the relevant court orders and court papers. So they need to start that process. Once they've completed that process, now they have the responsibility to ensure distribution of that estate, meaning distribution of the assets that have been given under the will are done according to the wishes of the person who's made the will. So an executor is a person who has all that responsibility rolled in one. And it's a huge responsibility. So we usually encourage clients, as they are thinking of making their wills, to think carefully about the people they want to make as executors. Because you don't want to appoint someone who is not able to do all those things to the end. You don't want to appoint someone who is not willing to do all those things to the end. Yeah, so that's who an executor is, and that's what they do.
That's thank you for that. And I think then maybe now what comes to mind is, so who can I appoint as an executor? And it seems like a very big role, because their role is to ensure that the land and the house and the car I have left for my child actually moves to my child and becomes their property. So who can I appoint? Are there rules the same way there are rules about witnesses? Maybe you can help us understand that.
Yes. The law provides a basic baseline for who can be appointed as an executor. So for starters, you can only appoint an adult as an executor. You cannot appoint a minor person as an executor, and it has to be someone who is of sound mind. So the same threshold that is used for witnesses in terms of age and soundness of mind also applies to an executor. However, the law doesn't get into the nitty-gritties of, oh, this person needs to be of a certain age, this person needs to have had a certain level of education. Now that is left to the person who is making the will. We find that the most natural way is for someone who is married to appoint their spouse as an executor, or their adult children, or their siblings. Some even appoint their parents, and others even appoint trusted friends. So your scope is as large as you want it to be, the main thing one needs to consider is that the person they are appointing is someone they trust and someone who they can see has the capability to ensure that they go through the entire process that we have just described to ensure that the wishes are implemented as under the will.
Thank you. I think that's very clear, and I hope people have understood. So it can be anyone, as long as they are adults, they have sound mind, and that someone at least you trust, yeah? And it can also be your children. So in this case, your children can be executors. It's not strict the way witnesses are as strict. Okay, I think then now maybe we can move on now to the other question. Another one that comes up is, we've seen cases in court where a 60-year-old or a 70-year-old has gone to court to prove paternity to a deceased so that they can get a share of the estate. Can adult people above 18, they are working, in fact, they've had families, they've retired themselves, can they claim from the estate of their parents?
Yes. Well, I know society thinks that you're a child when you're fully relying on your parent for your upkeep, you're fully relying on your parent for school fees, you're living under their roof. But legally, a child is anyone who has been sired by another, regardless of whether you are a minor, whether you are a retiree, whether you are a grandparent yourself. You are someone's child. And under the law, a child is an automatic dependent of their parents' estate. And dependent sounds like a big word. It just means that when it comes to inheritance, they are the automatic people who are considered to inherit from their parents' estate. So in that case, that 60-year-old child is entitled to seek help from the court to ensure that they get something from their parents' estate. Yeah.
Thank you. So please make sure you include your adult children. You can't leave them out just because they are above 18 or you feel like they're independent. In fact, the courts have referred to them as independent dependents. So they are still dependents despite them being independent and capable of taking care of themselves. So I think the other question that usually comes, you've stated as long as the child is sired. Is there another way that a person can be considered a child of the deceased, or that people should think about when they're considering, is this my child or not? And so that they know whether to include them in their will or not. And maybe Patience, you can help us answer that.
So over and above the children that you have sired, your biological children, the law also recognizes children that have been legally adopted by that person. So if you legally adopt a child that is your child, and you must provide for them in your will. And also if you assume permanent parental responsibility of a child, you take them as your own, you take them into your home, and you assume permanent parental responsibility over them, then those are also your children under law, and you must also provide for them because they're dependents, and they can always challenge your will if you do not provide for them. Yes.
Okay, so thank you for that. I think then it's also that a child can be beyond your biological child. It can be someone you have adopted or you've assumed permanent parental responsibility. Now we're living in an age where there are a lot of blended families, yeah? So a lot of people, different people sometimes, they come together and they get married, but they had children before, and then they get children together. So what happens in that case to the children that have come into a marriage with? Are they considered the child of the biological parent or the child of my now husband or my now wife?
Okay, for the children that you come into the blended family with, if the biological parent is still involved, those children are still the children of the biological parents. And so the biological parents are required to still provide for them in their estate planning. However, if the new parent in the blended family takes upon themselves, they assume the permanent parental responsibility, or they legally adopt this child such that the other parent is no longer legally involved in their lives, then the new parent, quotes in quotes, the new parent, then the children become their children. So again, it's all about establishing whether you've legally adopted them or you've assumed permanent parental responsibility over their lives. Yes.
Yeah, and I'm sure there are ways to consider that, which is why you probably need a lawyer to help you advise you on your unique circumstances, because people have very, very unique circumstances, and it is important that you seek legal advice to be able to understand who qualifies to be a child and whether you should provide for them. I think maybe the other thing that we'd want to discuss here is the society we live in. A lot of people support children of their friends, support children of their brother. Yeah, they help pay school fees. We live in that society, which is great because support is important. But what are the implications of that to someone who's trying to plan their estate? Must I provide for this child of my cousin who I have been supporting through school? And maybe Sheila, you can help us understand.
Thanks, Ivan, for that question. And it's really relevant in our African setting because we live in a community and that's what we do in our community. From the backdrop of describing who children are, it's important to perhaps distinguish. So someone who you're supporting, who you've not taken over permanent parental responsibility is not your child. But now you're in a situation where you have seen a need and you want to support that child to meet their education goals. Maybe it's primary school education, perhaps it's secondary school education, or even university education. We encourage that there be a clear distinction of the intention of that sponsorship, so that it's also known by the person who's receiving the sponsorship that this is not a lifetime thing. It's help for this specific situation. Now back to the question about the will. It is important for someone who is making a will, who is supporting another in any monetary way, to include that that person in their will. So what do I mean? So if, for example, Ivan, you're supporting someone from your village and you want to ensure they go through secondary school education, we encourage that as you're preparing your will, you indicate that you are supporting so-and-so. You have paid fees for, let's say, the first 2 years of high school. Your intention is to finish sponsoring them for their high school education. And so you're setting aside in your will a certain amount of money to cover that. It's important to indicate that so that there is no room for that person to think they have claim over more than what you had intended as the person who is sponsoring them and as a person who is making a will. Because as we said earlier, the whole purpose of making a will is to ensure that you provide for the people you want to provide for and any other, but also you make it in such a way that it is not open to contesting in a court and it's not left bare for someone to punch holes in it. So for good practice, for good measure, it's important to indicate that, so that even your executors know that, yeah, there's this responsibility, but it ends at this point. Yeah.
Okay, thank you. So I think it's starting to become clear why it is very important to do a will. Because then if you don't do a will, this person you're supporting may come and try and fight your children to get assets and to get assets in the same way from your estate. So it's very important. I hope we are all hearing this bit, why, and noting why it is very important to plan your estate early and to do it well and to include all these unique circumstances in your will and explain, so that any court that looks at your will can understand, oh, this person I was just supporting for education only, and they are not entitled to anything beyond that. Now, speaking of entitlements, I think the other thing a lot of people, and moving now to spouses, people want to understand, must I provide for my husband? I think it's always clear the other way around. Must I provide for my husband in my will? And does it have to be 50%? Do I have to give them equal? Yeah, so maybe Patience, you can help us understand.
That's a good question. Well, the law defines that, or rather it provides that dependents include spouses. And this is either husband or wife. So yes, you must provide for your husband because they are your spouse. Whether you provide for them 50% or not is really up to you. Just make sure that you provide for them what we call reasonable provision, such that the court is able to see that whatever you have given to them is reasonable and they can uphold such a bequest. So to answer your question, yes, provide for them. It needs not to be 50, it needs not be equal, but it needs to be reasonable under law. Yes.
And maybe just to piggyback on that, you've mentioned reasonable. What does reasonable mean? Does it mean enough for me to buy a car? Enough for me to pay for my medical? What does that look like?
Well, the courts have been clear that reasonable, first and foremost, does not mean equal. It does not mean that if you're giving your husband and your children your assets under your will, it has to be 50-50 to each. No. It just needs to be equitable. So there are terms that there are things that they look at. There are parameters that the court looks at when they're determining whether this bequest, or rather this gift that you've given to your spouse or to whomsoever in your will, is it reasonable? Some of the things they look at is the needs of such persons. I mean, if you have the 60-year-old child and a minor, then it will be unfair and not equitable to give them the same measure of assets. You can't give them 50-50 because the minor needs school fees, needs upkeep, and the 60-year-old, perhaps they don't need that, and they have their own means of income. So there are some parameters that the court looks at: the needs of the needs of the dependents, the sources of the means that they have to meet their own needs, the size of the estate, and such parameters. Yes.
Okay, so thank you for that. And I want to test our audience just a bit, just to see if they've been listening to us and that they're still with us. So there's a poll that is going to come up on your screen. I would like to hear your responses. One of them has already been answered, so I'm hoping you are listening. And I want to hear your responses to that. That's poll number 2. Yes, so I don't know if you can see the questions. For some reason, I can see it on my end. Okay, so the first question: do you have to share your assets equally among your dependents? This has just been answered. And the second one: how many years must I be cohabiting with someone for them to be considered my spouse? I mean, I think we live in a new age also. A lot of people are come, we stay. You start living together. You start a family. At what point are they considered my wife? Must I be living with them for 1 year? Or 5 years or 10 years? How long? Then the last question: can a joint bank account be included in a will? Again, feel free to also share any other responses you have on the chat if you feel like the options are not enough, or if you want to explain a bit more. I think it's been enough time now, so we can show the results of the poll. Great, so let's start. Number 1, do you have to share your assets equally among your dependents? 17% said yes, it's only fair. Now, I want to believe this is probably a dependent who's hoping for equal sharing of all assets. But I think we have already mentioned this. Patience has explained that it doesn't have to be equal. The test is not equality or even adequacy, because people are not, your parents are not entitled to leave you with everything you need until you retire. So the test is not equality, it is not adequacy, it is reasonability. And when the court considers what is reasonable, there are many things they look at. What is the size of the estate? Yeah. Had you been given any other form of support during your lifetime? For example, did your dad buy you a car? Did they build your house? yeah, and maybe there's someone else who didn't get the same level of support. So the court would consider that and maybe give this person who didn't get the same level of support a little more. So no, it does not have to be equal. And there are very many circumstances that the court looks at, including how the beneficiary was towards the deceased. How was their relationship? Yeah, so those are some of the things I consider, but it is very discretional on the court to decide how much to give to whom. But maybe I should state here, the court will do everything to uphold your will. Everything. They will try as much as possible, to the extent that your will is valid, to uphold your wishes in your will. Now, the second question, how many years must I be cohabiting with someone for them to be considered my spouse? 54% of you said 1 year or even less. 35% said 5 years. And then 11% said 10 years. That's interesting. I will have one of the panelists respond to that, but it's interesting that a lot of you actually say 1 year or less. And then there's the last one. Can a joint bank account be included in a will? 82% of you said yes. 18% of you said no. So we will also respond to some of this as we go on. Thank you for participating in the poll. I will just check if there's any charts explaining any answer. Okay, so I think it's just mostly questions for now. So maybe I can go over to you, Sheila. Help us understand, how long must I be cohabiting with someone for them to be considered my spouse? We've been doing Come We Stay for maybe at least more than a year. Are they my spouse? Must I include them in my will?
Oh, wow. You've given me the dicey one. I think the starting point is that the law and the courts encourage that people who want to get married should get married under the forms that have been provided. So we have several forms of marriage under the law. There's the Christian marriage and the Hindu marriage and the civil marriage, which are monogamous in nature, meaning that you can only marry one person. Then we have the customary marriages, which allow for polygamous unions, so as many as the specific culture allows. And then we have the Islamic marriages that allow for polygamy up to four wives. The law encourages that if you are in a situation where you feel sufficiently moved to get married according to the law. Go, do what you need to do, get your certificate from the Registrar of Marriages and have it formalized. And so the approach that the court takes is that a presumption of marriage, which is what cohabitation sometimes pushes people to, is an exception. It should not be another form of marriage under the law. So the court looks at it from a viewpoint, a very sensitive viewpoint. And so even as the court is applying certain measures when they look at a relationship between two people, it is viewed as an exception, not as the norm. So to answer your question, how many years should someone be cohabiting with someone for it to be considered a marriage? There is no hard and fast rule. I can't tell you it must be 5 years, it must be 6 years. It must be a length of time that is sufficient to prove to the court that these people were living together in a manner that they've passed themselves off to their community, to their neighbors, to their relatives as if they are married. And so there are certain requirements, there are certain checkpoints that the court would take a matter through. Therefore, we cannot just presume that because someone is living with someone and they've been living with them for a short while or a long while, then that automatically it will become a presumed marriage. Yeah, determining whether it's a presumed marriage is not for us. It's for the court. And unfortunately, you have to show the court that really you couldn't have gotten married under the forms provided. And they have to take that whole relationship through scrutiny of several steps to really prove that it is a presumed marriage.
Yeah, thank you for that. And maybe just to help us understand and maybe help the audience understand, what are some of these things, some checkpoints that the courts look at that you have mentioned? Maybe Patience, you can help us with that.
Okay. The Supreme Court recently made a determination on some of the checkpoints, as she's calling them, that they look at to determine whether a cohabitation truly falls under the presumption of marriage. So one of them is long continued cohabitation, which we all know of. The second one is the intention to marry. So they look at, or rather intention to be husband and wife. So they look at, for example, did you have children together? Did you have bank accounts jointly? Did you have properties held jointly? So that shows some intention to be husband and wife. Another thing they look at is if the community, they deemed you to be husband and wife, then that may be one of the reasons, or rather one of the basis on which they uphold your cohabitation as a marriage. The other thing they also look at is capacity to enter into marriage. So if one of you was already married in, let's say, a monogamous marriage, Christian or civil or Hindu, as she has explained, then you do not have capacity to get into any other marriage, even if it's a presumption of marriage, unless the initial marriage was, annulled or dissolved. So those are some of the criteria the courts look at to determine whether your cohabitation with the spouse, or rather this partner, can be presumed to be a marriage. Yes.
Thank you for that, Patience. I think we've all had, and I know I can see very strong sentiments. Someone has said cohabiting should be made illegal. Before then, it has not yet become illegal. And because this is the reality we live in, please decide, do you want to be considered husband and wife or not? If you want, the best way to protect yourself is to enter a valid marriage. Otherwise, it may come that the person you're with may decide not to include you in your will. And you will have to jump through these checkpoints in court after to try and tell the court, really he wanted to marry me or she wanted to be married. So it calls upon you to also think about what it is the intention is. If your intention is to not to be considered married, fine, but just understand that you can't claim from that person's estate. It becomes even more difficult when you start acquiring assets together. Yeah? So that is just to help you understand that position. Someone has said, side chick must enter into a valid marriage. Yeah, But just to, and maybe just to come up from that, and Sheila, you can help us understand. There are certain ways that people are considered a wife under the law. So I think it is clear, for example, that if you have a legal marriage, you are a wife. What is another instance, a peculiar one, where someone would be considered a wife under succession, but not a wife in marriage?
Yeah. Oh, wow. The question about wives and who can be considered wives is something that is asked so many times, and I think it's good to clarify. So first, a wife is someone who has contracted a marriage with a man under either of the 5 forms of marriage that are provided under the law. So if you have a certificate of marriage, whether it is Hindu, Christian, Muslim, customary, or civil, then you are considered a wife legally under the law and under the law of succession. The second person who is considered a wife, and this might surprise all of us, is a former wife. And by former wife, we mean if you are married and you have gone through the divorce proceedings to dissolve your marriage, or annulment to annul your marriage, but you have not tidied up that whole situation, meaning that there's no settlement, there's no division of matrimonial property. It was just done, but it was not fully done. You're considered a wife under the law of succession. The third category, and maybe just to dial back to the ones who are legally married, if a couple separates and they don't go through the divorce proceedings, it doesn't matter whether they've been separated for 20 years or 30 years, the law of succession considers them married, therefore the woman is considered a wife. And if a man decides to get into a cohabitation situation with somebody else, that first woman who he did not divorce is his wife for purposes of succession. The third category of women who are considered wives is quite interesting. These are the women who would not ordinarily be considered wives under the laws during the lifetime of the man. But when he passes away, they are considered a wife. What do I mean? So if a man is living with a woman who he has not contracted a legal marriage with, and that woman is able to prove presumption of marriage, she's considered a wife when he passes away. Or if that man entered into a monogamous union and then did not tidy that divorce up and gets into a cohabitation situation with another woman, both women are considered wives for succession purposes. It sounds very confusing, and I think it's deliberately confusing to push people to do an estate plan that is clear. We encourage people, whatever situations you found yourself in. We have clients who have been separated from their spouses for years, and we've encouraged them when they come to do their wills with us, finish off that divorce, do that settlement, tidy it up, and then come and have your will properly prepared. Because if you leave out that person, they have a legal claim, and they will be able to come and contest your will in court and get orders to be included as your dependents in your estate. So it's important to consider these factors when preparing a will. And if you find you have a former wife as a man in any of those categories, or you have someone who might be considered a wife, and you don't want to finish off what you need to finish off, then provide for all of them in your will.
Thank you for clarifying that. I hope that I seen someone had already asked that, who is a wife. So thank you for going through that. And I hope that now answers the issues of who is a dependent. And I think Sheila has and Patience have both talked about automatic dependence. You must provide for your spouse, both husband and wife, including all those definitions of wives, and your children, including the definitions of the different children that we have discussed. So now let's discuss some of the assets that you can include in a will. And there's a question that we had on the poll. Can I include my joint bank account in my will? So maybe, Patience, you can help us understand. Can you include joint assets in your will?
Okay. So maybe I should start by explaining what joint assets are. Joint assets are assets that are held by two or more people, but they do not have a divisive interest in that asset. What do I mean? If you and I have a joint ownership in a piece of land, we both own it 100%, such that if either of us passes away, then that piece of land automatically devolves to the other person who is still living fully, entirely, 100%. So the piece of land, if person A was to pass away before person B, that piece of land will not fall under their asset, or rather under their estate, but it will fall automatically into this person B will automatically own it. So there's no divisive interest in that asset. So joint assets, it's another way of succession planning. And what we usually advise is for joint ownership, you should ensure that it's clear that this asset is jointly held. Otherwise, it may be presumed, especially for land, it may be presumed to be tenancy in common, whereby you now each have an interest in that asset. So again, using an example, let's say we have 3 people, they own property under tenancy in common. When either of them passes away, when one of them passes away, it does not mean that their interest is it automatically, there's no more interest. What it means is that their interest now becomes part of their estate, and they can bequeath their interest to whomsoever they wish. So that's the difference between tenancy in common and joint ownership. Joint ownership, both of you own it 100%. Tenancy in common, you each have interest in that asset, and you can bequeath your interest in your estate planning measures. So joint accounts or joint assets, what do you do with them? Now, it's advisable that you still provide for them in your will. That is because, well, there are chances one of you might pass away before the other. And if the other person passes away before you, then it's important that include in the will that should, in this property that I jointly own with so-and-so, should they predecease me, or rather should they die before me, then this is how I wish for that asset to devolve, because remember, it becomes now part of your estate. Yes.
So maybe let me give you a few scenarios. Patience. My friends and I, 3 of us, own land together, and all it said is Ivan, Patience, and Sheila are in the title deed, and they are owners of this land. So the title deed only reads Ivan, Patience, and Sheila. Is that tenancy in common? What does that mean? Is that tenancy in common?
That is tenancy in common.
Okay.
Because as I've mentioned, it has to be clear that that property is jointly owned. Otherwise, it's presumed that it's held under tenancy in common.
Okay.
Yes.
So if me and my spouse have land in 2 of our names, but there's nothing that says as joint tenants, that is not tenancy in common.
If it's still tenancy in common.
It's still tenancy in common.
Yes, it's still tenancy in common.
Okay, great. I hope that is clear. So, and the reason why we are having this discussion is just to help you understand. Look at your assets, look at your titles. How do your titles look? Yeah? So if your titles just read this person A and person B, the end, there's nothing that specifically states as joint tenants, then that means the asset will not automatically move to the other person. It means that part of that asset belongs to you. And if there's no description about how you're sharing the asset, the assumption is it's equal shares. Okay? Yes. But joint accounts usually, and maybe the bank, they're here, they can let us know, joint accounts, usually it moves to the person who's surviving.
Yes, in the case of joint accounts, yes.
Okay. Now, Sheila, there's a question that came from our other webinar where someone said, my spouse and I had a prenup agreement. So we did a prenuptial agreement before we got married and all. And they're wondering, how does this affect my will? How does it affect how I distribute things in my will?
So I think to be able to understand the implication of a prenuptial agreement in a will, we need to understand what a prenuptial agreement is to begin with. So a prenuptial agreement is a document that is prepared by 2 people who are intending to get married to one another, and it clearly has the purpose of clearly demarcating or distinguishing which properties are, how their properties are going to be treated. So we've seen situations, especially where people are getting married older, and by older I mean perhaps in their 30s or in their 40s, and they've already gotten to a point where they have started to acquire assets for themselves in their own names. We find a lot of the time, some of them don't want these properties to be, to form matrimonial property, which is property that would be owned jointly by the couple after they get married. And so a prenuptial agreement would just distinguish that the man has come with 1, 2, 3, and they've agreed that those 3 things will remain in his name, and that in case of anything, those 3 things will continue to remain in his name. The woman has come with another set of 3 assets, and she doesn't want for those 3 assets to form part of the matrimonial property, so they'll remain in her name. Prenuptials, essentially, their purpose is really appreciated in the case of dissolution of marriages, because then when a marriage is dissolved, there is the whole aspect of how do you divide property that has been acquired by the couple during the timeline of their marriage. So prenuptial agreements would cure that, because then quickly they would identify the properties that are not being considered and move. But for the law of succession, if either the man or the woman are preparing a will, then it is clear they will have, you see, you can, when you're preparing a will, you are writing in the will how you want your property to be treated after you pass away. So this man and this woman have these items that they have retained in their names by virtue of a prenuptial agreement. So they still have control over who they want those properties to go to. It doesn't stop them from saying they want a property to go to the spouse. It doesn't stop them from saying they want a property to go to somebody else. So in so far as wills are concerned, prenuptial agreements don't affect them, because the person making the will still has ownership over those properties. The question would come in where someone passes away without a will. And so in that case now, the court would step in to apply the rules of intestacy, which we mentioned earlier, are the rules that are applied where someone has passed away without a will. And so the court now has to determine how to distribute these assets. So that is where it would, that prenuptial agreement would essentially fall away, because a court would be looking at what assets are owned by this person and how are they to be distributed. A prenuptial agreement in that sense then would not stand, because its applicability is not specific to the law of succession.
Thank you. I think that is well understood. And maybe just to clarify and to help people understand, really what you include in your will is an asset you own, an asset in your name. So you cannot add things in your will that are not in your name. But there are instances where, this land is, and we've had clients come and say, it's ancestral land. I have an interest in it. It is not in my name yet, because we haven't done succession of my grandfather, because that has not been done for 60 years. But really, me and my children have an interest in that. Can I include something in my will that is not yet in my name, but I have an interest in it?
Thank you. I believe that is my question. So yes, if you have, and we have so many instances that are similar to that, where our clients perhaps are in the process of buying property and they have not yet received the title deed. So in such circumstances, we advise that you still include that property in your will. And you can always describe it. You can say that my land in this and this place, which has this, it measures this, it's, 1 acre in this location, then such property I bequeath it to my children, let's say equally. Why? Because if you do not provide for it and yet you have an interest in it, then it will fall under the rules of intestacy. So again, it's important to provide for it in your will and, just clearly state who exactly it should go to. Yes. Okay.
Thank you for clarifying that. So basically what you'll be saying in your will is, I have an interest in this property, but when it eventually comes to me in my name, then I want it to go to this person. Okay, I hope that is clear and that will help a lot of people. I think maybe now we can move on to, Sheila, you've discussed distribution, yeah? And a lot of people want to understand, if someone died without a will, what do the courts do in that case? How do they distribute assets in that case?
Okay, so then that means we would be discussing briefly what the rules of intestacy provide. I think just to confirm, when we are encouraging people to do wills, the reason for that is because as a person who is making a will, you have control over who you want to give a certain asset to. When the rules of intestacy kick in, you lose that level of control, because now the court is involved, and perhaps some assets that you didn't want to fall in the hands of some of your beneficiaries will have to end up in their hands anyway, because there was no plan that you put in place for that. So the law provides a certain guideline that the courts consider when looking at how to distribute an estate of someone who's passed away in the case that they have died without a will. So the automatic dependents who we discussed are the spouses of the person who's the spouse or spouses in case of polygamy of the person who's passed away, their children. Those ones are automatic dependents, and so the court has them on their priority list when it comes to distribution of the estate. And this category of people don't have to prove that they are dependents of the person who's passed away. So automatically they are considered in the list of who is to get the assets of the person who's passed away. The court also, in some instances, will consider the secondary level of dependence, but these people will have to show that the person who passed away was maintaining them immediately prior to their death. So if there is perhaps a parent, an elderly parent, or maybe a sibling or a grandchild, those would have to prove, and the court would consider that when looking at how to distribute the estate. The court also considers if the beneficiaries come together and agree. These are the assets that have been left, and we've discussed, and this is how we see is a fair distribution of the estate, and they put down their agreement into a document and take it to court. Then the court, once examining that agreement, can adopt it as the mode of distribution of the estate of the individual who has passed away.
Thank you for that. So it is when there's no will, then the law comes in.
Yes.
And the law generally says equal.
Yes.
But then sometimes the court will shift that depending on the different circumstances. Okay, so, and this is again, as Sheila mentioned, why we're encouraging a will, because there are certain things that the court will not do if you don't have a will. Let's say you really wanted to leave something to your church. If you die without a will, your church cannot come in play. Yeah? So it is very important to draft your will so that you're able to even give the people who do not have a right under law to benefit from your estate. Okay, and as we're discussing now, this is now, death has happened, the will is now starting to take effect. Maybe Patience, you can help us understand what happens. People know, we've seen a case where people are aware or had heard some rumors that this person had a will, but they can't find it. They have looked for it everywhere. They have advertised on radio. They have advertised on newspapers. It cannot be traced. What happens? Does that will become invalid?
That's a good question. Well, as we have mentioned here severally, one, it's really important that someone knows where your will is. When you're notifying your executor, which you should let them know where your will is, which lawyer has it, so that once you pass away, then they can reach out to the lawyer and inform them, and then the necessary processes begin, including the reading of the will. So again, to emphasize, please, once you prepare your will, let someone know where it is, so that you don't find yourself in this situation where people are announcing in radio stations and TV asking whether they have seen your will, anyone has seen your will. Now, in case they have done all that announcing and they still can't trace your will, then you will be deemed intestate, and your estate will fall under the laws of intestacy, the rules of intestacy, and now the courts will have to distribute it in accordance to the law, which now defeats the whole purpose of where you prepared a will, where you perhaps wanted to make certain distributions, to, as you said, the church and whatnot. These people now might not have the chance to get those gifts under the rules of intestacy. So again, to emphasize, please ensure that someone knows where your will is. Otherwise, your estate will be deemed intestate, and the rules of intestacy will come to play.
Thank you so much for clarifying that. So we are emphasizing, please let someone know, one, that you have a will and where your will is. And maybe we can clarify, they don't need to know what is in your will. You don't need to tell them what you said under your will. They just need to know that you have one. It was dated this date, because sometimes people come with differing wills. I think we've seen that in court. Someone has a will from 2000, another one has a will from 2014. So it's not clear which one it is, yeah? So it is important that you let someone know, especially your executors, where your will is, what is the date of that will, and for you to confirm that that is the right will. Again, they do not need to know what is inside your will. Okay, so we had an interesting question that came from the last webinar. There was a Catholic priest who asked, can I bequeath as a priest some assets that I have in my will, or must they devolve to the church? And I'm going to let Patience answer that and help us understand, yeah.
Well, I wonder why I have been chosen. But anyway, so from the question, I understand that this is a priest who has property in their name, and they wish to know whether they can, gift it to whoever they wish. If you have property in your name, there is a testamentary freedom to gift it to anyone you wish in your will. So, to this father, if you have any property in your name, please, you have the testamentary freedom to do so. However, I understand that while taking oaths in the Catholic Church, in one of the oaths is that you do not own assets in your name. And so in such case scenario, then before perhaps you take the oath of, if you had any estate, then you can bequeath it to, your family members, or if you had even received inheritance from your father or your parents, then you can bequeath it prior to making the oath. Or even you can also bequeath it to the church. Nothing stops you from doing that. However, if you had dependents, remember there's a rule of ensuring that your dependents are reasonably provided for. So before making the oath, you can always first, distribute your estate or rather your assets accordingly before making the oath. But in this case, and from the question, it seems to me that this father has assets in their name, and the testamentary freedom applies to all. Yes.
Okay, so I think what I've understood is that the determining factor is there anything in your name?
Exactly.
If there is, you can bequeath it in your will.
Yes.
Okay. Now, Sheila, I think what other people like to understand, especially after death comes, is we found out that my mom had some debts, yeah, that she was still paying. She had not finished paying, and now they're wondering, how do we manage these debts? Whose responsibility is it to pay the debts? So,
all right. So that is the reality we have. People take loans sometimes before they are able to pay them off. Unfortunately, they pass away. And I think that question is coming from a point of, is this loan going to be passed on as a risk, as a liability to the beneficiaries of that estate? The answer is no. It won't pass to the beneficiaries of the estate. The people who will have the responsibility, in a case where there is no will, because in a will we would encourage you to state what loans you've taken and with which financial institutions. So in a case where it is a person who's passed away and there is no will, it is the responsibility of the administrators. The administrators play the same role as the executors. It's just that they have a different name because there is no will that has been prepared in the scenario that they come to be. So it is the responsibility of the administrators as they are collecting the estate and putting it together in the case of intestate succession. It is their responsibility to ensure that the estate has enough to pay off those debts, because those debts fall to the estate and not to the beneficiaries. So it is their responsibility to ensure, first of all, that all the debts are paid off before any distribution of the estate can be done. And those debts can only be paid after they've gotten the court orders to deal with the property of the deceased.
thank you for that, Sheila. So really, it is the estate, which means sometimes whatever money in bank account that was bequeathed maybe to someone may have to reduce. Yes, because it has to be used to pay for the debts. Okay, so I hope that's clear. And there was a question where someone had asked, how do I protect my beneficiaries from my debts? The best way we can answer this is ensuring that you have set up mechanisms for that debt to be paid. A lot of loans these days have insurance, which you pay for. So when you pass on, the insurance will cover it. So ensure that you have got that in whatever loan that you take. But if it was maybe a debt from a friend or from whatever, and you are aware of it while preparing the will, please include it and state which money or what money from what bank account or what should be sold to pay that debt, so that people are not now being, their inheritance is being reduced, and that's where some of the conflicts come, because the money in the bank account is used to pay the debt and this person was not left anything else. So obviously they want to get some more from the other people. So it is important that you include your entire scenario, including the debts that you own, that you hold and that you're still paying off. It doesn't mean don't do a will. Please do a will. Just state it that you have this debt and you're paying it in this manner, and there's insurance, or if there's no insurance, this is the money that will be used to clear the debt. Okay, I think we can now move on to trusts, and I know there were a lot of questions that came up on trusts, but before then, I want to just check in with my audience and to ensure that they're still with us and that they're still engaged. So we're going to have another poll that is coming up, just to hear from you before we move on into trusts. So the poll is now up. I want to understand from you, now that we have discussed wills and there was the other webinar on wills and trusts, what would you use to plan your estate? And maybe you can add now in the chat box why you have selected the choice you have selected. Would you use a will? Would you use a trust? Or would you use a combination of both? So we'd love to hear from you about that, and feel free to give more explanation on your answer in the chat box. Then the second one, do you think that once you create a trust and you've transferred assets in the trust, what is your understanding? Do you have control over those assets? The first answer is yes, because they're your assets. Or two, no, the trust takes over. So I'll wait to hear from you guys. I'll give you a few minutes. Feel free to also post in the chat your reasons for the answers given. Thank you, Abraham. Thank you for confirming that you're engaged. It's very encouraging to see that. Thank you. Yeah, so just one more minute, and then I will read your responses. Someone has said it's getting hot in here. It is. Is it getting harder? The questions are getting harder by the day. It is. Okay, thank you for confirming that you're locked in and that you're engaged. It's very encouraging to us. Thank you. So I think we can see the results of the poll now. Great. So it should be up on your screen. So on the first question, what would you use to plan your estate? 27% of you say will, 21% of you say trusts, and 52% say a combination of both. That is very encouraging to us. We're very happy to see that. And I will read your reasons in a few minutes. Then the second question, would you have control over your assets once you move them to a trust? This was literally split in the middle. 50% of you said, yes, they are my assets. 50% of you say, no, the trust takes over. So let me just read some of your explanations on the chat. One person says, I choose trust because it's not contested in a court of law. Yeah? I mean, gladly, we've heard of the Karume 1-1. And maybe we can explain whether a trust can be contested in court. We will discuss that. Someone has said, I would love control, keen to understand your view on living trust. Yeah, so I guess that's in the response to the second answer. Do I still have control once I create a living trust? Someone has said, my brother's assets were moved to a trust that manages it. That's how I know you have no control. So this is explaining, yes, once assets move into a trust, the trust takes over. So their understanding is that once the trust takes over, you have no control over your assets. Someone has said will. Someone has said trust will back the will and vice versa. I'm guessing this person answered a combination of both, which is great. Someone said both to ensure continuity. Someone said in the response to whether you have control over assets once they move into a trust, said property remains yours until you die. Does it? Does it? Someone said will is straightforward and frees everyone. I am guessing they chose will in that case. Great, I think those are enough for now. So I will ask my panelists here, my very educated panelists, please help us understand. Once assets move into a trust, maybe I can direct that to Patience. Once they move into a trust, does the founder of the trust still have control over the assets?
Well, I like the answer that you own the property till you die. That's funny. But anyway, so once you settle the trust into the hands of the trustees, once you move it from yourself to the trustees, then the trustees become the owners of that asset. And they hold it and manage it on behalf of the beneficiaries that you have named in your trust deed or in your testamentary trust. So, no, you do not have control over it, or rather you also do not own it, but there are ways to still maintain control over it. For example, you can still name yourself as the initial trustee. So that means you'll still continue to manage it, not as an owner, but as a trustee of that asset or property that was moved into the trust. So yes, in a simple way, that is the answer. No, you lose the ownership and the control of it, but there are measures that you can take to still maintain control. For example, being one of the trustees in the trust, yes.
Thank you so much for that, Patience. And I guess we can start now also from there with you, Sheila, just to help people understand who is a trustee, what is their role in a trust, and yeah, just to understand that. And can the founder, Patience has already said the founder can be a trust. So who else can be a trustee? Who else can be a trustee?
Okay, thanks, Ivan. So a trustee is an individual who is appointed by the person who is creating a trust to hold assets and manage them for the benefit of a third person or a third party. So it's important to note that trustees do not manage the assets for their own individual benefit. It's for the benefit of others. And so the structure of a trust has a founder who is the one who's creating the trust, the trustees who are given the responsibility to manage the assets that are now owned by the trust and managed on behalf of now the next group of people who are the beneficiaries, who are entitled to enjoy the assets that have been placed in the trust. So that is who a trustee is. Yes, a founder, in the case of a living trust, a founder can include themselves as one of the initial trustees in the trust that they are creating. And a lot of them would do this, I think, to still have some level of control over the assets that they are placing in the trust, and then also to ensure that this trust is running well during their lifetime, and to also ensure that the trustees they have appointed are doing what they are supposed to do. Trustees are bound to their responsibilities of managing assets for the benefit of beneficiaries. They are bound by the law. There are specific statutes that bind them. And so if they act outside of what the trust deed empowers them to do, then they would be acting against what the law provides, the responsibilities of a trustee. So I don't know if I've answered the question or whether I've gone on my own tangent.
No, it's okay. You've answered the question and explained a lot more. So
Yeah.
thank you so much for doing that. And I think maybe a lot of people want to understand now that I've created a trust. I'm the founder as Ivan and have appointed Ivan and Patience as trustees. Yeah. Can Ivan still be a beneficiary of the trust? Yeah. Is that allowed in Kenya? Maybe Patience, you can help us understand that.
Yes, that is allowed in Kenya. You can still be a beneficiary in the trust, and we have seen such instances as we prepare trusts for our clients where they wish to also be a beneficiary, for example, so that when they are elderly, they are able to be provided for from the trust. So in simple terms, yes, you can include yourself as a beneficiary in the trust.
Okay, so thank you for that. And I think maybe what else people want to understand is, you know, the way in a will, I have to include my spouse, I have to include my children. In a trust, do I have to do the same? Am I bound by those rules?
No, you're not bound by those rules. The law of succession is clear who the dependents are. However, the Trustees Act or the Perpetual Succession Act does not provide any dependents that you must name in your trust. So you are free to create it as you wish. And I think this was also mentioned in the first session, what trusts are and what they serve. So one is to create and preserve wealth for generations. And another reason why people create trusts is, for example, to take care of someone with special needs. So in such case scenarios, you need not then name everyone in your trust. So no, you don't. There is no requirement to provide for all your dependents in your trust. Yes.
Okay, so just, and maybe just to understand, is this because once the asset move into the trust, they are no longer your assets? Is that the reason?
Yes. And as we have emphasized here, once it moves to the trust, it ceases to be yours. So it ceases to also be part of your estate. So you cannot gift it in your will unless it's a testamentary trust which is created through the will. But otherwise, it ceases to be your estate, and then so you cannot devolve it, or rather, you cannot gift it away. Yeah.
Okay, it's interesting you've mentioned testamentary trust, and I recognize we haven't discussed that yet. So maybe we can help the audience understand what is a testamentary trust, what is a living trust. Sheila, you mentioned that. What is the difference between the two, and how do I choose which one to pick?
Thanks, Ivan. It's important to distinguish between the two types of trusts. So a living trust is one that is established by the founder during their lifetime. So it takes effect during the lifetime of the one who has created it. And in that instance is what we are proposing, where a founder wants to still have control over how the purpose of their trust, then they can also be one of the founding trustees for that trust. On the flip side, a testamentary trust is created under somebody's will. And that means that it only takes effect when the person who's created it has passed away. And we have certain situations where people who come to us to make a will have a need to create a trust. For example, if they have minor children who are very young, and they are worried about how the maintenance of these children will continue after they have passed away. Perhaps they have a certain lifestyle that they want to maintain for their children for years to come, even if they are not still alive. Or perhaps, as Patience mentioned, they have a child who is living with special needs. Or perhaps they have a certain beneficiary who they want to take care of or ensure that their standard of life continues even after they've passed away. Then we would encourage them to create a testamentary trust. So that is the main difference between the two. Both types of trusts have trustees. Both types of trusts have assets or funds. And the trustees in both types of trusts are held to their responsibilities by the law. And they are beneficiaries in both types of trusts. The difference is how the trusts are created and when they take effect.
So maybe just to understand, if I had a testamentary trust, so this is a trust inside a will, if my will is declared invalid, what happens to that trust? For example, maybe patient.
If your will is declared invalid, the trust also becomes invalid.
So that is one of the risks of not having a living trust, that the will must remain valid for the testamentary trust to take effect. Okay, thank you for that. And maybe patience, a big question that we get whenever we discuss trust is tax, tax, tax. And a lot of people want to understand what are some of the tax benefits available if I do decide to set up a trust. And in this case, I think we can specify that it's a living trust, because a testamentary trust does not take effect until after death. Yeah.
That is indeed a big question. So there are tax benefits that are allowed for family trusts. One is when you're transferring assets and properties into the registered family trust, those are exempt from stamp duty as well as capital gains tax. So that's one of the benefits someone gets when they're transferring their assets into the family trust. The other one is when they're also transferring the assets from the family trust to their beneficiaries. Those are also exempt from stamp duty and capital gains tax. Remember, I'm talking about beneficiaries here and not third parties. If you're transferring it to a third party, that may attract stamp duty or capital gains tax. So in a nutshell, those are the benefits.
Yes, thank you. And there's someone from the previous webinar who had specifically asked, if I want my pension funds to move into a trust, will they be subjected to tax?
If that person meant that they want to withdraw, under the Retirement Benefits Act, they want to withdraw their pension and then transfer it into the trust fund, then that principal sum is not does not attract any tax, or rather it doesn't attract any income tax. So I don't know whether that's what they meant. If not, if maybe they were asking whether you can nominate your family trust as a nominee for your pension, then there's no law that prohibits that. So yes.
Okay, thank you. And I think the other thing that people usually want to understand, especially with living, but trust in general, the costs of managing a trust. Are trustees paid? Must they be paid? Is it based on the size of the estate? Maybe Sheila, you can help us understand that.
That's a good question. And we're finding we are faced with that question a lot, because now people are more sensitized about the whole trust arrangement. And so when someone is approached to be a trustee, those are the questions they ask. Are you going to pay me a stipend? What is it? What's in it for me? So I think, just perhaps to start off, where someone is appointing a corporate trustee, and that is a trustee that is not an individual, a natural person like you and I, where you're appointing a corporate trustee, which is a company or a legal entity that runs the business of managing trusts, then there is a cost that you will have to pay to have them offer those services to you. And the charges vary. They would consider, the trust assets, or perhaps the size of the trust fund. And so those are costs that one would have to be aware of. If you're having a corporate trustee, there is a fee that you'll have to pay. Where it is a natural person that you are having as a trustee, the founder can provide. There's nothing that stops them from providing it under the law. In the trust deed, they can provide for a small stipend for trustees, and it can be something that is done every so often, just to appreciate the services that they're offering. Again, the role of a trustee is really heavy, especially if a trust has assets that that has a wide asset base. Then the responsibilities on those trustees is heavy. So just, I think, as an appreciation, it's allowed, you can have it, but it's not mandatory to have such a cost for trustees. With respect to establishing a trust, one who wants to create a trust would have to consider the costs of registering the trust, if that is the method they want to go through. So the law prescribes certain costs that are applicable when one wants to register a trust. Also, the costs of engaging a legal advisor to hear you out, to hear what your wishes are, to help you craft a trust that best suits your needs and your vision. So there is the legal fees as well. If you're going to engage the services of a tax consultant to give you a more in-depth look at your asset base and advice on the tax implications for your trust, then there is a fee that you would be expected to pay them for their professional service to you. So in a nutshell, those are some of the costs that one would need to consider when thinking about setting up a trust.
Thank you. Thank you for that, Sheila. And the other thing that people usually question, you have stated that trustees have a duty, certain duty under law. In fact, the biggest one is a fiduciary duty. Yeah. So what assurance is there that a trustee will live up to their duties? And if they do not, what remedies are available?
It's important to have a trust deed that is prepared clearly to state these are the limits of the powers of the trustees. You don't, again, want to have a situation where you're giving people a blanket, a blank check to move with, because then controlling and managing and creating systems of accountability will be difficult. So as someone is forming that trust, have your trust deed prepared in a very clear manner. Let it be known to the trustees that these are their responsibilities. Again, as we mentioned, the trustees have a fiduciary duty, which basically means they are bound by law to always act in the best interest of the beneficiaries and not in their personal interest. So in a case where a trustee is acting outside of what has been provided in the trust deed and outside of what has been provided by law, then there are measures beneficiaries can pursue, go to court to pursue, relief, or to take the trustee, to report the trustee for acting outside of their powers. We also have the concept of an enforcer in a trust, and we encourage founders, especially of big trusts, who are creating trusts that have a lot of assets or a lot of beneficiaries, or any other dynamic that we foresee might cause a problem in future. We encourage them to have an enforcer added to the situation, and the main responsibility of an enforcer would be to keep the trustees in check. So if the trustees act out of line, then the enforcer would have the responsibilities to draw them back to what they're supposed to do. And beneficiaries also have the entitlement to seek answers from trustees who are acting outside of the powers that have been given to them in the trust deed. So outside of what the trust deed provides, outside of what the law provides, enforcers and beneficiaries, and even fellow trustees, if they are disagreeing with other trustees, there are measures, there are ways that they can report this bad acting and pursue either removal of the trustee or any other penalization of the trustees' actions.
Thank you, Sheila. So maybe that's just to clarify for the person who said that trust can't be contested. It is possible, and usually it's people trying to hold trustees into account. So it's possible for someone to go to court if they feel like their trustees were mismanaging the funds under their care, which is what, by the way, happened in the Njenga Karume case. So the trust was upheld, but the trustees were removed so that others can be appointed. Okay, I hope that is clear now. And now, final question to you, patients, because we're out of time. We had asked the question, will, trust, or both? Why should I choose a trust over a will? Or should I have both? What would you advise?
Well, the two instruments serve different purposes. We advise that you should always have a will, for starters, as the basis. Why? Because not everything may be transferred to your trust. And remember, a will is a legal declaration of your wishes of how all your assets will be distributed. So one, you should have a will, which is properly drafted with the help of a lawyer, preferably us again. so that you ensure that all your assets are properly provided for and it's clear to whom they will be going to. Now, the trust is it's a supplement to the will. So you are able to then provide for whatever assets that you wish to get into the trust fund. Then you can transfer them to the trust fund, and and it serves different purposes. As I mentioned earlier, it may be not maybe, but to create or preserve generational wealth. So, in summary, those are two different instruments that serve different purposes. You should have a will, and depending on what you want, you can have then the trust as a supplement to your will. Yes.
Thank you, Patience, for that. I think that's clear that you can have both, and you can have different ideas about different assets in your estate, and that's what we're trying to demonstrate, that there's a bank account that you have. You don't want that to go in your trust. You want to have control over your salary that is coming in every month, maybe. You don't want your bank account in your trust. So that is one of the things you'd still need to include in your will. But maybe there's a piece of land that this one, I want them to never sell it. It should fit my grandchildren, great-grandchildren, even when I'm not here. So then you can set up a trust for that particular asset. So it's possible to have different estate planning tools for different assets that you hold. And I think I will stop there. We have talked for so long. Thank you so much for engaging with us. These are our contacts for anyone who may want to reach either Mboya Ngongo and Wayaki Advocates as the legal firm, or to contact Absa Bank in case you have any questions or you want anything further beyond this. And I'm going to hand over the session back to Onesmus.
Wow. That was quite insightful, amazing. I'm one of those who have never taken up a will, just a basic will. But I promise you that we shall be setting up a date immediately after this, because I have to take one immediately. So thank you very much. I think we want to appreciate you, our panelists. That was quite insightful. And the questions are so many, so many. And I think we shall continue responding to some of them virtually. If need be, we can even set up a third webinar, because we clearly see that this topic is quite sensitive and very interesting to most of our viewers. So as we come to an end of this webinar, we'd like you also, as you just reflect on the year, as you look at the successes and the areas of development, we kindly request you to just make to make estate planning a key objective for you, even as we go into 2026. And the good news is that our customers, we've already negotiated for you very favorable rates, of course, in partnership with our partners here, Mboya, Wangongu, and Wayaki Advocates. So if you're an Absa customer, please feel free to reach out to us. If you're not an Absa customer, no need to worry. We shall be sharing our contacts. I think they have already been displayed. We shall display them again. Reach out to us. We shall onboard you so that you can also be able to enjoy these favorable rates. And as a bank, what I just want to reiterate is that we shall continue offering such kind of financial and wealth management solutions at every stage of your life, even as we go into the new year. Today's session, again, it shall be loaded on our YouTube channel. If you missed out a thing or two, please feel free to just go and look at the recording. I just want to thank everyone. Thank you, everyone, for logging in. Thank you, our panelists. We really appreciate you. Asanteni sana. And at this point, I'd like to take this opportunity from Absa Bank to wish all our viewers happy holidays. God bless you, and have a good day ahead. Thank you.